what happens is, so therefore, as far as sanction is concerned, what could sanction do and how much could sanction help in this regard? To some extent, Hart takes this understanding forward, and we will see in the third part that I'm going to begin now. That is, in the third part of this chapter, Hart discusses about legal validity and moral values. So here, Hart says that protection and benefits in mutual forbearance. If you remember, while discussing minimum content, mutual forbearance was something that Hart had propagated to be one of the basic, things which is required for a legal system. That is, mutual understanding and mutual, dependence on each other. So mutual forbearance. So, and Hart agrees that this is important not only for law, but this is also important for morals. And therefore, it may extend to a different range of people in the society. And this is very interesting that Hart says that while we talk about mutual forbearance, the amount of help or probably the amount of dependence that person A has might be more compared to person B. So it depends on the means and depends on the position and every other hundreds of other factors. So therefore, again, if I consider this mutual forbearance that in the second part Hart says is one of the essential baselines of evolving the legal system, Hart himself talks here or even talks about the challenge here, and he says that this could extend to different people up to in the society differently. So therefore, suppose my mutual forbearance is more. So let us say, for example, a person who is wealthy, his or her dependence on the rest of the people might be equal or less. That is again a matter of perception and our morality while we discuss. But then the point is that a person who has more means, his or her mutual forbearance would be, let's say, at a lesser degree than a person whose means are limited. So therefore, even if mutual forbearance is based, which otherwise seems to be a good logic to have as the basis of law, again the problem arises is how will you ensure that everybody is having the same kind of or the legal system should be applicable in such a way that this difference in mutual forbearance is acceptable to different people, or it ensures that to different people it changes according to the varied degree of their requirement. And this is a place where he himself tries to analyze what he has said previously and tries to bring out that what could be the challenge if the legal system itself is based on this mutual forbearance concept. And then Hart goes forward to say that denial of these elementary protections might offend the principle of morality and justice again. So since mutual forbearance itself differs in degree between different people in the society, to one person, when you are allowing to have one set of, let's say, laws which is protecting the person, it could be that the other set of laws is that set of law is not enough for the other section who has nothing. This is the place actually where Hart tries to sow the seeds of protective discrimination kind of a concept, and later on he does take that up in little more details, where he says that yes, one section of the society much might require more protection than the others. So, however, as of now, so therefore he contends that the moral outlook is that when humans are entitled to be treated alike, so the treatment should be alike, and the difference in treatment needs to be justified. So the equality or the equality of treatment must not be from the end of the person who is imparting the treatment, but rather it should be equal from the in respect of the persons who are accepting it. Now, because these people have different stages in life, or they stand in different stations in their life, so therefore that requirement is something that the law needs to take into consideration. And the differential treatment then, Hart says, becomes essential. And it is something like, let's say in Articles 14 of the Indian Constitution, like we have equality, but we also have Articles 15 and 16, which is imbibing these understandings. And we do know that how and why these laws are important, at least the laws enacted under Article 15 and 16. But whatever, Hart goes forward here and says that since we are basing our understanding on mutual forbearance, history has always shown that even if most of the people need this mutual forbearance, there are always some people who do not need, and they do not pay heed to these kind of mutual forbearance. So either for them they are too powerful to need mutual forbearance, or their immediate requirement becomes more more important to them rather than thinking about the long-term security and other things that the society is built upon. And this is exactly the point where Hart comes up and says, we need sanction. So in the previous part, if you note, where he said that sanction is not the, cannot be the basis of a legal system like like Austin or Bentham has contended. But here he says that although mutual forbearance, he continues to say that although mutual forbearance is the basis and is required to be the base of any legal system, but however, the legal system also needs to have some form of sanction, because even this is not a foolproof thing and it cannot imbibe every person in its purview. So that is something that Hart says. And however, if the rules are being made, there must be sufficient number of people who will follow it voluntarily. So that is why he's pointing on this mutual forbearance concept, that it should be such a law and it should be made in such a way that most of the people will be voluntarily agreeing to follow it based on these understandings. And according to Hart, or the only thing that might tie all these people together to be binded together in one legal system. However, there will be some exceptions, and for them sanction is required. And going ahead from here, then Hart talks about that this sanction, or giving this sanction, or having the provision of sanction, then creates authority. And this authority may be used in two ways. So one is against the malefactors, the persons who do not follow the law, the persons who are not abiding and doing something which is against the law. And the second, which is again very interesting here, is he says for subduing a group. And this group, subduing a group, like when you are unable to hold these malefactors, when these malefactors may be, because you remember before he has already discussed that if there are malefactors, why are they so? Why are they not agreeing to abide by the law? So where he said that maybe because two reasons, either they are too powerful for mutual forbearance, or maybe their immediate requirement is more important than the long-term goals. So these were the two alternatives Hart had said, due to which there could be people who do not abide by the law. And here he comes up and says that the authority that is being made through the provision of sanction might be applied in two ways. One is punishment of the malefactors, and on the other, he's saying to subdue a specific group of people. So if you're unable to hold back the malefactors, what you do is you subdue a group of people. These are not the beneficiaries of laws, but they are rather victims of law. And this is very interesting because if you see in the Indian society, there are so many such practices, there are so many such situations where we actually see that where the law is unable to reach the people, or maybe there is a law and that law is either not sufficient or not mutual forbearance, where also there are challenges, where also, I have to keep sanction. And despite that sanction, also there are some category of people who might not fall in that strict sense of law, and I will have to deal with them in their way. To some people, I will have to punish. To a category of people who are weaker, maybe I will have to impose the law on them, to subdue them, whatever the situation might be. But despite that, morality cannot be the ground. Because if that is not what law is, the second category is more dangerous. In the second category, we don't know where to draw a line. We don't know where to stop this morality, and whose morality are we talking about, most importantly. And then he goes forward to lay down 6 forms of claims in this regard, and we will discuss them one by one. So the first one is power and authority. And it is said that power and authority, it is said that the moral obligations is very important even in a legal system. So as we know that Hart did not completely deny the existence of morality, but it cannot be said that it is based, so some morality is there, because we cannot say that the legal system, instead of being based on morality, will be based on, the power of man over man, because that is going to be, again, a very detrimental kind of a society. And between this this dichotomy between law based merely on power and law accepted as morally binding, this is not exhaustive. This will continue. And allegiance to the system may be based on several factors. Here again, he's recognizing that whatever the system is, be it based on muscle power, or power and authority, or based on morality, there could be a number of factors that why people are following it. So the first one, definitely, like we have been discussing till now, is for a long-term interest that I live the peaceful manner in the society. It could also arise from the fact that I'm really disinterested in the interests of others. Who is having what problem, it does not matter to me. I don't care about it. That could also be an attitude. It could also be the unreflecting inherited or traditional attitude. So, for example, women not being educated, or even if women are educated post-marriage, all they are supposed to do is stay back and cook for the family, is a kind of unreflecting inherited traditional attitude. Whether there is a law there or not, it does not matter to me. Even if there is a law, it is okay, but this is what I think, this is what should happen, and this is what I do, irrespective of what the law is, and if at all there is a law. Question. And it could also be based on that mere wish to do as others do. So since other people are following the law, since other people are doing something, so even I do that. So this therefore does not show that when people are abiding the law or not abiding the law, whatever. This does not show that they are acknowledging something as legal obligation that one has accepted as moral obligations. So what Hart says is that when most of the people are accepting or abiding by the law, or there are a category of people who are not abiding by the law, whatever the situation is, the point is that this legal obligation that is being made, not necessary that this is a moral obligation also. It could be it could be based on the reasons of moral obligations, which Hart is not completely denying. It might not also be the situation. So the second point is influence of morality on law. Here he directly discusses how law is influencing, and it's very interesting that towards the end of this chapter, where this portion, where Hart says that there are various ways, there are various points from which morality enters the legal system. It could be through the legislation itself, to behavior or the judicial process. So even, and this is where he very strongly says that even the positivists cannot deny that the stability of a legal system depends partly on such correspondence with morals, and its existence needs to be considered. Under any circumstances, the existence of this morality needs to be considered. Up to what degree, in what respect, for whom, all these things might vary in degree. But yes, the existence of morality as one important component of law, that needs to be considered. The third point that Hart talks about is interpretation of law. And here, again, Hart says that it is the choice of the judges, which are guided by assumptions that whatever the outcome is, or whatever the verdict is, it should not cause injustice, and it should not offend the settled moral principles. Again, he goes back to the debate, takes us much deeper into, and probably a little more confusing. That is, on one hand, he says that, the minimum content and it might not be good enough. But on the other hand, while he talks about interpretation and entrance of law in the legal system, he very categorically says that even the judges are influenced by morality, and which is something which cannot be denied. We also know that. And he says here that, when I'm talking about morality, what morality am I talking about? Is it my personal morality? Because morality also differs from person to person. Or is it the morality of the settled moral principles of the society? And this again takes us to the complicated question, what if the settled principle of morality is not correct? So, for example, so many examples are coming in my mind. Let's say, the Naz Foundation case, or the Triple Talaq case, or marital rape. Naz Foundation, Triple Talaq is chalo, फिर भी वो तो settled है. Let's take the marital rape case. So, this is one area. Moral, जो societal moral है, वो तो established है, that you enter into a marital relationship. The basic foundation of family as a system, as an institute, social institution under the sociology and anthropology, is essentially to legitimize the offspring and to ensure that there is a proper family system, and either of the two people do not venture into such adventures which might cause ill effects on the society at large. So we all are understanding that. But intrinsic to this is also a concept of marital rape. So does marrying a woman gives the husband the power or the free license to enter into physical relation with the woman, despite the fact that she might not like it, or it is not her consent there. So is consent at all important? So the established social principles, if we have seen historically, probably it will say that Of course, that's how it is supposed to be. That is how you get. That is why you get married at the first place. On the other hand, today, the more liberal people, if we contend, we will rather say that no, marital rape is a crime because consent is important. With or without marriage, the consent of both the parties is absolutely essential. So this is something which is unsettled, and probably this is a glaring example what Hart tried to say while he discussed this point. So, therefore, he goes forward. He goes ahead and says that it involves choices between moral values, and it is not applicable on a single moral principle. So, it's moral values. So, when we talk about these regards, it is about moral values, and there is no single moral principle that one can follow, and everybody will, be satisfied with that. And because morality too does not always have a clear answer. So here, what normally these judges do, what the kind of alternative or the kind of what do I say, something that Hart comes up with as a better concept is, he says that here then for interpretation, the judges will then look for all alternatives. They will survey all the alternatives, which will consider the interest of maximum number of people or almost all the people, and that thing should be adopted. But again, because Hart has been very careful about taking all the aspects of challenges and criticisms in mind. So here again he says that this finally accepted principle might not always be correct, but at least this the legal system has this base that it is it is a reasoned product of informed and impartial choices, which is again a very important thing. So this displays that weighing and balancing characteristics are required to do justice between contemplating interests. So while this is done, interpretations where morality is a base, but again, because morality does not have an answer to everything, so what a judge is required to do, or what judges usually do, is they scrutinize all alternatives available. And while they go for one, for example, again, something that comes up is the Shabrimala case that, has been extremely in debates in recent times. So while the alternative might not always be correct, the outcome might not make everybody happy, but at least it is known that it is the best, it is the outcome of a reasoned alternative, reasoned scrutinization of all available alternatives. In the fourth point, Hart goes ahead to say, to talk about the criticism of law. And here the assertion that a good legal system must conform to the requirements of justice and morality is itself a criticism of law. Why? Because does morality with which the law conforms, that need to be good? While we talk about a law to be good, a legal system to be good or bad, do we talk that the morality on which it is based, is that good? And if that is what we are contending, is it for the group of people for whom it is made? Or it is for everyone? And if it is only for the people for whom it is made, it could easily be based on superstitions as well. FGM, female genital mutilation, is one glaring example. There are so many umpteen number of such examples. So, some like about protection of slaves is something that Hart himself has mentioned, that, do you need to protect slaves or not? So if you have a belief system or a superstition that slaves are born because they are supposed to, serve you, and because you win them, in a war, or you buy them, then, can you say that this legal system is a good legal system? Because this legal system is also based on this morality, on this belief. So, but even if they are considered, they cannot alter the fact that the municipal legal system with primary and secondary rules have endured, even if these principles of justice have been flaunted. They have been openly disregarded. Despite that, the legal systems have endured. And this is again where we go back to Hart's understanding, where he said these are prescriptive laws. So the legal system prescribes the laws, but even if you do not obey the laws, there are a number of people who will not obey the law. Despite that, it does have this, it is still a valid law. The next is the principles of legality and justice. And here he says that the very concept of good and bad law is a fallacious system. Because when human behavior is controlled through general rules, it contains some basic points of morality and justice. It always has to be there. The minimum form of justice, which is reflected through implementing, let's say, the natural law principles in the procedural laws that we always do. Like, we always follow the odi alteram partem and nemo judex consensuum. So these are always followed, and these are some basic minimum form of justice, and these are also parts of natural law philosophy, but we always ensure that. If confirmation of people's behavior to social control is expected, the rules then must necessarily satisfy certain conditions. Number one, it has to be intelligible. So therefore, even if you're creating a differentiation that Hart also at one point recognizes, that has to be based on intelligible differentia. The capacity to obtain obedience from most people. So not all people, not possible. We have seen that there are two categories of people, the malefactors and the people who need to be subdued. But they could be a small or relatively smaller percentage of people, and vis-a-vis obeying the law, like the number of people who would be obeying the law, they should be, the greater the number, the better the legal system is. And they generally should not be retrospective. And I think this is somewhere where the last class, somebody, I think Anjali had asked me this question about the Nuremberg trials. And I had said that yes, Hart did take up this aspect somewhere. And he goes forward with this to some points. And he said that therefore those who are punished for breach have the ability and the opportunity to obey. Not going back to the retrospective point, we will come to that in some time. But as far as these basic characteristics of legal system is concerned, Hart is saying that these are the basic characteristics which for a legal system to sustain and to be followed by maximum number of people. This is important. However, punishment, of course, also needs to be a part of the legal system. But it is important to ensure that these people who are being punished, they also had an opportunity to obey the law. So law need not be arbitrary this way. So it is a law which can be easily accepted and followed by all people. It is not creating chains or it is not binding people, but it is something which is which can easily be obeyed by people. It is not difficult to follow the law. And here some critics have noted between law and between law and morality, and they suggested to call it the inner morality of law. So this is something that many of the critics have preferred to call it, this part of it, the inner morality of law. So the last point that he says is the legal validity and resistance to law. And interestingly, he says that there are two views to the law. One view is that when people are asked to obey an established law, and they may consider that the law is too iniquitous or too immoral to be applied or obeyed. Many a times it happens that there could be a lot of laws which the people might resist to obey. And the opposed view is, after a revolution, the courts considered their attitude to moral iniquities committed under the earlier regime. And this is where the retrospective operation comes. So suppose the existing legal system had certain flaws in it, and after the legal system has already been changed, or there has been a change in rule or whatever, then they understand, then they realize or scrutinize or go deeper into it and understand that the previous law that existed was iniquitous. Where punishment, and in these circumstances, punishment is felt socially desirable, but effect a rule, but in order to implement a rule retrospectively, maybe again morally audacious or sometimes immoral, something that the Indian society has faced after the Nirbhaya case. So, we completely maybe reason out with this point that even if after a change has happened, we feel that whatever has happened under the previous legal system was a flaw and that needs to be changed, but we cannot punish that person. Because retrospective operation of law is something which is again coming back to the moral values of it. It is morally incorrect. When somebody committed the crime, if that was not a crime defined under the law, then you cannot make it a crime later on. And this is a principle which is, established in most of the international, covenants and international agreements, including the EBHR, CEDAW, and every other such thing. So therefore, it becomes impossible to then implement. And here, it may be tempting to say that the enactments which permitted iniquity previously should be invalid. For example, what happened in Germany after the fall of Nazi rule. So it is when you are retrospectively looking into a law and then you are scrutinizing it and saying, it is very easy to say that what you have done under the previous rule is wrong. But can you punish the person for whatever was done previously, either in two situations, like the Nirbhaya case, what happened when the crime was committed, this boy who was below 18 years of age, he was, cannot be brought within the legal, not legal framework, under the provisions like adults are treated. and his matter went to the juvenile board instead. So that was one thing, something committed, but the law said elsewise, or that was not a law that could include him within the purview of the law. And on the other side, if you see after the fall of Nazi rule, when these generals who had acted under the command of Hitler, and later on they might not like it. I mean, it is quite possible that there are some of the people who would not abide by the law because they might feel that it was wrong. But because it was law then, they had to do it. Later on, when the trials began, and then they were punished, was that punishment valid? Does that punishment give a valid understanding? And even if it is tempting to say that the previous regime was wrong and what you did under the previous regime was wrong, punishing under that previous regime might be grossly problematic. So the wider concept is that the primary and the secondary rules, even if they offend the morals of the society, we consider them to be enlightened or true morality. And the narrower view is that it is to exclude this offensive rules. Why does Hart call it the narrower view? That this narrower view could lead to a lot of confusion there. If you say that, you simply take it up and you say that I exclude that law and whatever you did under that law was wrong. If you do that, it is a narrower view because it creates a lot of confusion. In the wider view, then he goes on to explain this point. In the wider view, we can accommodate the study of iniquitous laws, and then we can, understand what their reactions from the society have been, and we can change the law accordingly. So here, this is a better approach to law than directly saying that previous regime or that previous system was a wrong system. Law is not a certification of obedience, but the majesty or authority, and this is somewhere I quote, majesty or authority of law must be submitted to a moral scrutiny. And this is towards the end, the concluding parts where he says, therefore, that after discussing all these concepts, that we cannot go with the narrower view, and rather the wider concept which allows us to, scrutinize the law and then understand that what the reaction of the society is, and take the law in a different way, mold the law according to the changed moral principles, if any. So that is a better view. And this will help in the long run to minimize the iniquitous factor in the legal system. So, on one hand, this point, that scrutinizing the law and coming back and then understanding, Hart contends that this is a better understanding because, authors like Austin and Bentham has, in this regard, tried to differentiate between what law is and what law ought to be. So this ought factor and what law is factor, has a lot of challenges and all. But while you derive the law from this system, like this, first going by mutual forbearance and then having a legal system backed by, some form of sanction, although knowing that sanction might not be enough to stop the people from, acting as malefactors, and you might have to have other alternatives to that as well. However, when the problem arises, when you have a system of law which is enabling you to revisit and understand that what the flaws were, and in order to bridge those gaps, you have the opportunity to approach the society and then take the feedback and then change the law according to the, views of the people or change morality of the people. It is a better system. That's what Hart says. And finally, the last word that I would like to conclude is also one of the last lines in the article, that a concept of law which allows the invalidity of law to be distinguished from its immorality. So invalidity of a law is distinguished. A law to be not a valid law not necessarily always has to be immoral, or it might be immoral, but how do you decide whether it's valid or not? This system, if I'm giving this wider perspective, enables us to see the complexity and variety of these separate issues. Whereas the narrower concept of law, which denies legal validity to iniquitous rules, may blind us to them. So with this, I would like to conclude. If there is any question, I would be very happy to take them. I think it is a little complicated, but yes, I've tried my best to give examples so that some sort of understanding is there. But yeah, a discussion would be very good.
Yes. मैम, तो फिर क्या ये कहा जा सकता है कि एचएलए हार्ट ने एक तरीके से बेंथम और मिल के उपयोगितावाद को ही आधार मानते हुए मोरल वैल्यू के सिद्धांत प्रस्तुत किया है।
किसके बारे वो कहा आपने, मिल और
बेंथम और मिल की जो जिक्र आई थी डिस्कशन में, हाँ। कि जैसे लॉ अगर कंफ्लिक्ट हो जाता है तो आंतरिक और बाह्य नैतिकता के आधार पे जज तय करते हैं, उनके प्रिंसिपल्स अलग अलग हो सकते हैं, और अगर प्रिंसिपल में एक प्रिंसिपल अगर मॉरल वैल्यू मान दिया जाए तो जज अधिकतम लोगों की अधिकतम उपयोगिता के सिद्धांत जो कि मिल और बेंथम द्वारा दिया गया था वो एक मोरल वैल्यू के रूप में आ जाते हैं और वाइडर व्यू हो जाता है लॉ का। तो क्या एचएलए हार्ट यही करना चाहता है, यानी एक तरीके से वो बेंथम और मिल के सिद्धांत को स्वीकार कर रहा है?
बेंथम ने एग्जैक्टली ऐसा नहीं कहा था कि मोरालिटी वाली बात एग्जैक्टली बेंथम का वो कहना नहीं था जो हार्ट ने कहा। हार्ट का अंडरस्टैंडिंग ऐसा है कि देखिए, जहां बेंथम वाज अ पॉजिटिव, बेंथम बिलोंग टू द पॉजिटिव स्कूल, तो जहां बेंथम ऐसा कहते हैं कि लॉ जो है वो कम्प्लीटली डिवॉइड ऑफ मोरालिटी होना चाहिए, और जब मैं लॉ को बना रहा हूँ या लॉ को इवॉल्व कर रही हूँ तो ये ऐसा होना चाहिए कि वो जो लॉ है उस पर कोई इन्फ्लुएंस नहीं होना चाहिए। लेकिन बेंथम ने ऑल्सो ये कहा यूटिलिटेरियनिज्म के द्वारा कि ज्यादातर लोगों के लिए वो बेनिफिशियल होना चाहिए, जिसके अगेन देयर आर लॉट ऑफ अदर चैलेंजेस, हम उस पर नहीं जा रहे। हार्ट ने एग्जैक्टली ये नहीं कहा। हार्ट ने ऐसा कहा कि वेराज ये माना जाता है कि कुछ हद तक तो मोरालिटी जरूरत होती है। देखिए, अगर हम बेंथम के बेसिस पे जाते हैं जहां पे वो बोलते हैं कि लॉ वही होना चाहिए जो ज्यादातर लोगों के लिए एप्लीकेबल हो, तो ज्यादातर लोगों के लिए एप्लीकेबल तो वो लॉ भी हो सकती है जो माइनर सोसाइटी, जो माइनर सेक्शंस के लिए नेगेटिव है, इमोरल है। तो हम मोरालिटी को उस बेसिस पे या लॉ को उस बेसिस पे तो नहीं कर सकते। लॉ इज नॉट फॉर मैक्सिमम नंबर ऑफ पीपल, लॉ इज फॉर ऑल द पीपल। तो जहां सोसाइटी में बहुत छोटे से एक वर्ग है जिसको हम मैनुअल स्क्रैवेंजर्स कहते हैं, हम सबको कुछ आता जाता ही नहीं, उनके लिए हम लॉ बनाएंगे ही नहीं, वो जो भी करे उनके मुताबिक, ये तो गलत बात है, इस पे तो मोरालिटी कहीं है ही नहीं। और बेंथम बोलते हैं कि हमें ये देखने की जरूरत भी नहीं है। दिस इज नॉट व्हाट हार्ट सेज। हार्ट ने कहा कि जहां पे एक तरफ पॉजिटिविस्ट ये कह रहे हैं कि सिर्फ सैंक्शन ही लॉ को इनेबल कर सकता है, वहां हार्ट आके कहते हैं कि बेसिस तो एक लेवल पे मोरालिटी होना बहुत जरूरी है, क्योंकि अदरवाइज वो जो सिस्टम है उसको हम कैसे इनेबल करेंगे, लॉन्ग रन में वो सिस्टम कैसे चलेगा। इवन इफ इट इज फॉर अ स्मॉल सेक्शन ऑफ पीपल, वी नीड टू थिंक अबाउट दैट, एंड अगर हम नहीं करते तो वो सिस्टम तो मॉरल हुआ ही नहीं। हार्ट का जो मेजर अंडरस्टैंडिंग है वो ऐसा है कि मोरालिटी तो हम ले रहे हैं, लेकिन हम मिनिमम कंटेंट नेचुरल लॉ से ले रहे हैं, जितना मिनिमम कंटेंट अप्लाई करना जरूरी ही होता है। बाय चांस अगर, और जब हम आगे बढ़ते हैं, मतलब इससे तो लीगल सिस्टम बन गया, और जब हम आगे बढ़ते हैं जहां पे केस के बेसिस पे इंटरप्रिटेशन आता है या हमें नया लॉ बनाना होता है, तो वहां जाके जो जजेस है या फिर जो लेजिस्लेटर्स है वो जो चेंजिंग मोरालिटी जो है, और हार्ट इज वन ऑफ द लीगल थिंकर्स हु हैव accepted this concept that morality also changes, and this is absolutely true. So he says कि जो previous society में morality था, हो सकता है आज वो morality नहीं है, या फिर जो previous society में लोग बात नहीं करते थे अभी वो करते हैं। तो ये change होता है, सोशल इकोनॉमिक चेंजेस के साथ साथ ये सारी सिचुएशंस भी चेंज होते हैं, और इसके साथ साथ लॉ को भी चेंज होना जरूरी है। लेकिन अभी बात ये है कि लॉ किस बेसिस पे चेंज होगा और कौन डिसाइड करेगा ये जो चेंज हो रहा है सही है कि गलत है। अगर हम सबरीमाला का एग्जांपल लेते हैं, तो इतने सालों से जहां ये चलते आ रहा है कि women are not supposed to enter the temple of this particular age, menstruating women are not supposed to enter the temple. So when this writ was filed, the Supreme Court decided, good, bad, correct, wrong, I'm not going into the other factors of it. I'm saying what the Supreme Court said. And the Supreme Court said this is, not equality. This is actually creating a discrimination between the devotees of the Lord himself. So that means what? We recognize that there is a change in morality. सही गलत हम उसकी बात नहीं कर रहे। तो हार्ट ने कहा कि ऐसे जो चेंज होगा तो जजेस क्या करेंगे, वो एस्टैब्लिश मोरालिटी को देखेंगे और देख के सोसाइटी का रिएक्शन देख के उसके बाद वो चेंज करेंगे। लेकिन ये जो चेंज हो रहा है वो मोरालिटी के बेसिस पे ही हो रहा है, और हर जगह पे एक नहीं एक से अधिक मोरालिटी को वो इस विषय में देखेंगे, परखेंगे, समझेंगे, उसके बाद इसको अप्लाई करेंगे। तो ऐसे में गलत भी हो सकता है जो भी आउटकम है, लेकिन अगर गलत भी हुआ तो एक satisfaction होगा सोसाइटी के पास कि this was done after proper scrutinization of every alternative available. So this is what Hart is saying, and that is where he says कि morality इसलिए लगेगा, तो basis तो morality है ही, हम उसे deny तो नहीं कर सकते। Could I answer you? This was Rakesh, right? Could I answer you, Rakesh?
Yes, ma'am.
Okay. Anyone else?
Hello, ma'am.
One
Yeah,
by
Karthik, go
one.
ahead.
Okay, so okay, ma'am. Ma'am, so the minimum morality idea that Hart talks about, I think it lands us in some sort of difficulty. So, what is the minimum that Hart is trying to say? So, because it's very uncertain. So, different persons again may have different views about it, and it is bound to be different at different stages of history. So, मतलब Hart obviously mentions five features, and again Fuller goes ahead and conceives 8 features, and others may conceive different features. So that is my point actually. So this is yes, ma'am.
Okay. So, Karthik, first of all, I will start answering your question with the fact that this is a question which is open before the legal fraternity since, I think time immemorial. So, having said so, मैं हार्ट का पॉइंट ऑफ व्यू बताती हूँ. जब हार्ट ने मिनिमम कंटेंट की बात कही तो हार्ट tries to actually propagate that ये जो म्यूचुअल फोरबियरेंस जिसको हार्ट बहुत इंपॉर्टेंस देते हैं, तो हार्ट बोलते हैं कि ये जो व्यक्ति सोसाइटी में एक व्यक्ति दूसरे व्यक्ति के ऊपर डिपेंडेंट है, किस हद तक डिपेंडेंट है और उनका ये जो म्यूचुअल डिपेंडेंस है वो कैसे आगे बढ़ेगा, या फिर ये म्यूचुअल डिपेंडेंस को हम प्रॉपर लीगल सिस्टम में कैसे इम्बाइब कर सकते हैं, ये जो सारे एस्पेक्ट्स है, हार्ट सेज द मिनिमम कंटेंट ऑफ लॉ और द मिनिमम कंटेंट मिनिमम मोरालिटी उसका उत्स यहाँ से है. द बेस बिगिंस फ्रॉम हियर, इट इज बेस्ड ऑन दिस. लेकिन आगे जाके ऐसे काफी जगह है जहां पे हार्ट बोलते हैं कि बेस भले ही ये म्यूचुअल फॉरबियरेंस हो, लेकिन ये म्यूचुअल फॉरबियरेंस कैन नॉट बी द एंड. इसके आगे जाके भी ऐसे बहुत सारे अलग अलग एस्पेक्ट्स है, अलग अलग मैं क्या बोलूं, अलग अलग एवरीडे लाइफ के बहुत सारे पर्सपेक्टिव्स हैं जिसको while the law evolves with the evolution of law, these moral principles will also evolve. But the base, however, the minimum content जो है, वो however is rooted in the concept of mutual forbearance. फिर आगे जाके अलग अलग ऑथर्स ने अलग अलग तरीके से इसको एक्सप्लेन किया है, लेकिन हार्ट का एक्सप्लेनेशन यही है कि म्यूचुअल फॉरबियरेंस से मिनिमम कंटेंट आता है और जैसे जैसे ये आगे बढ़ता है अलग अलग विद द इंक्रीजिंग डे द complexities of law and the areas of law will also evolve. तो वहां पे with the evolution जो societal morals होंगे तब, जब मैं societal morals बोल रही हूँ, it means the maximum of course जो ज्यादातर लोग सोचते हैं, that will come into play. Not always ज्यादातर मतलब in terms of number of people as Bentham has propagated, not that, but a sense of right and wrong that evolves from there will come into play. But the overall point, I don't think it is very clear to any one of us. I think if anybody else would like to comment on this, Hairas, Anumeha, I think Anita is also here today. If you think you want to comment, yes, you can come forward and say this. But what I understand is that this has always been a debate, and this has always been open to discussion in a class like this, in a jurisprudence class. Karthik, could I at least make you understand the background?
Yes, ma'am. I could understand it. But maybe after reading Fuller, maybe we'll have some.
Yeah, when we read Fuller, a little more with things will come. Yes.
Yes, also, just adding to what Ruchita said, Karthik, what Hart means by minimum content of morality is that, so if you look at Hart and start studying Hart from the very beginning and then try to contextualize his minimum content of morality, what we'll understand is that for Hart, rules come in the form of obligations, right? And he agrees that the primary rules of law, like other rules of law themselves, are obligations per se. Now, and he also recognized, this is in the very beginning, if you read the initial chapters of concept of law, he also recognizes initially that there are several rules which are overlapping. So several forms of rule which may which may not per se qualify as legal rules, are still present as moral obligations. So they will not necessarily be legal obligations. And when you read the segment on minimum content of natural law, and you look at the different characteristic features or truisms that Ruchita discussed in the classroom today, that there are different truisms about minimum content of natural law. What Hart was trying to basically say was that there are certain requirements without which humans cannot exist as a society. And those minimum requirement is what Ruchita was also explaining, that those minimum requirements are what would perhaps in Hart's sense qualify as minimum content of natural law. Now, having said that answering your question, that obviously morality changes from society to society, and the content of this minimum content of natural law may keep on varying depending on the society that we live in. But the idea, so you have to understand the idea what Hart is trying to promote, that there are certain basic truisms without which human society cannot exist. For example, he says the truism about human vulnerability, that, and the example that he gives is that you cannot kill, that individuals cannot kill each other, right? So this is the basic characteristic. The fact the social life cannot exist without restriction on killing or inflicting bodily harms. And this is the basic requirement of minimum content which is required for any law to exist. And therefore, when Hart says that I agree to minimum content of morality, he is not agreeing to morality in the sense, let's say Fuller is agreeing to, but rather he is agreeing to morality or the law having some content of morality in a manner that morality which is minimally required for human society to live. And then Ruchita, as Ruchita also pointed out, once we study Fuller and come to Fuller, this aspect will become further clearer, especially in the Hart-Fuller debate that we will. Yeah, that's it.
Thank you.
Shabaz, you had a question?
Yes, ma'am. Actually, my question is related to the last class, not this class, but I did not mention this initially because the question is quite long. So, in the previous class, we discussed about this morality differs from society to society and individual to individual. Then, particularly, we have been discussing about change in legal obligation brings change in moral obligation. Like we have been taking examples of homosexuality and sati. But has Hart discussed about change in legal obligation based on change in moral obligation? Because last time Anjali mentioned about marital rape, so I read further on it. So in 1890s, like the then Viceroy, he brought an act to criminalize marital rape, but many leaders then, like Bal Gangadhar Tilak, they stood against this. But over the period of 100 years, there is no legal change which has been brought up, but we have seen the moral change. So does Hart or any other philosopher talks about change in legal obligation based on change in moral obligation? That's my question, ma'am.
Okay. So I will try to answer your question to my best of whatever I understood. I think what you were trying to ask, Shaz, if I understood you correctly, is it that you're trying to say that since morality evolves with time, so and lot of authors including has said that the legal obligation is based on moral obligation. But is there a moral obligation which is based on legal obligation? Were you asking this question?
Yes, ma'am, related to like change in legal obligation based on change in moral obligation.
Okay. So, first of all, the thing is that with the change in morality, the law will anyway change. And Hart has incorporated this in his discussion overall. Because when Hart says that minimum content of law is where the law begins with, and then going forward, with the change of time, with the change of the societal understanding, morality and everything, the law is bound to change, which is obvious. We understand that. And there is no denial to that fact. As far as legal obligation is concerned, while you are creating laws and rules, there has to be some sort of morality in it. And Hart also towards the end of the chapter, if you remember, has discussed that morality is bound to enter the system either through judicial activism or even through legislations. If you see all the legislations, over the time and the way that it has changed, so when we do an analysis of these laws, we will see that the ideology that the law follows has also changed. And why do you think that the outlook of the law, or today we say that the society is modernizing? So how do you think that this modernization of law happens? How do you think that one after the other, the laws which were enacted in the past are being repealed now, they are replaced now, newer thoughts are being encouraged, and at least in the legal aspect, things are being included, like transgenders. They were never included in the legal perspective before. But now, we have a third category for the transgender people. We are also recognizing the LGBTQ rights. Why do you think this is happening? While it is not a legal obligation completely, for example, in a form you have to mention the categories where a third category has to be there is a legal obligation. But at the same time, in a society where, entrance of a transgender person was per se considered to be, what do I say, difficult, bad, wrong, or, evil, this kind of things were there. Today that is not there. Is it only because of the legal obligation? Do you think that it is a legal obligation which made us change the way that we think? No, it is also with the changing perspective on morality. It is also with the change of understanding of the people that there are categories of people who do need special rights. There are categories of people whose rights have been not recognized over a very long time, and it is high time that we start giving them that place that they ought to be. And while we talk about this, again, I would like to take you back, since we are talking about morality here in a sense, to the natural law school, which says that by virtue of being born as a human being, you have certain rights on this earth, and that nobody can deny. What are those rights? That will depend based on society to society, their morality. And yes, with the change in morality, legal system is obviously dependent upon, which is true and which cannot be denied. But, and I think both are interdependent. We cannot say that the morality is changing, but the legal perspective will remain the same, because if that remains the same, obviously we cannot change the morality as such. On the other hand, sometimes when the morality is difficult to change, for example, triple talaq, the law is affecting and changing the morality there also. So it is either way. They are not this or this, but they are rather complementary to each other, and they move together. One cannot be left behind, or one cannot be said that I do not consider you while I take the other forward. That, in my opinion, this is my personal opinion, is not possible. And Hart, to a very great extent, has, in a different form, has probably imbibed this understanding itself, that apart from minimum content of the natural law also, when you go ahead, there are certain important aspects where this morality does crop in. And in one place, he has also said that, even the positive school people cannot deny this. This has been there. This has been the ultimate truth always.
Yes, ma'am. Thank you, ma'am.
Yes. Any other question? Okay. So I think there is no question from students. Harris, would you like to make a comment? Or Anita, would you like to make any comment before we wrap up? Okay, so can we end the class then? Anumeha, should we end the class then? I think it's over. Okay, so see you tomorrow then. Students?
Okay, just a second. Tomorrow we will positivism and separation of law. That is the read that we are going to pick up. Again, obviously. So if you have any questions related to what I discussed, or Ruchita, even ask questions of that.
Yeah. Okay, thank you so much, students. Bye. What happens is, so therefore, as far as sanction is concerned, what could sanction do, and how much could sanction help in this regard? To some extent, Hart takes this understanding forward, and we will see in the third part that I'm going to begin now. That is, in the third part, of this chapter, Hart discusses about legal validity and moral values. So here, Hart says that protection and benefits in mutual forbearance. If you remember, while discussing minimum content, mutual forbearance was something that Hart had propagated to be one of the basic, things which is required for a legal system. That is, mutual understanding and mutual, dependence on each other. So mutual forbearance. So, and Hart agrees that this is important not only for law, but this is also important for morals. And therefore, it may extend to a different range of people in the society. And this is very interesting that Hart says that while we talk about mutual forbearance, the amount of help or probably the amount of dependence that person A has might be more compared to person B. So it depends on the means and depends on the position and every other hundreds of other factors. So therefore, again, if I consider this mutual forbearance that in the second part Hart says is one of the essential baselines of evolving the legal system, Hart himself talks here or even talks about the challenge here, and he says that this could extend to different people up to in the society differently. So therefore, suppose my mutual forbearance is more. So let us say, for example, a person who is wealthy, his or her dependence on the rest of the people might be equal or less. That is again a matter of perception and our morality while we discuss. But then the point is that a person who has more means, his or her mutual forbearance would be, let's say, at a lesser degree than a person whose means are limited. So therefore, even if mutual forbearance is based, which otherwise seems to be a good logic to have as the basis of law, again the problem arises is how will you ensure that everybody is having the same kind of or the legal system should be applicable in such a way that this difference in mutual forbearance is acceptable to different people, or it ensures that to different people it changes according to the varied degree of their requirement. And this is a place where he himself tries to analyze what he has said previously and tries to bring out that what could be the challenge if the legal system itself is based on this mutual forbearance concept. And then Hart goes forward to say the denial of these elementary protections might offend the principle of morality and justice again. So since mutual forbearance itself differs in degree between different people in the society, to one person, when you are allowing to have one set of, let's say, laws which is protecting the person, it could be that the other set of laws is that set of law is not enough for the other section who has nothing. This is the place actually where Hart tries to sow the seeds of protective discrimination kind of a concept, and later on he does take that up in little more details, where he says that yes, one section of the society much might require more protection than the others. So, however, as of now, so therefore he contends that the moral outlook is that when humans are entitled to be treated alike, so the treatment should be alike, and the difference in treatment needs to be justified. So the equality or the equality of treatment must not be from the end of the person who is imparting the treatment, but rather it should be equal from the in respect of the persons who are accepting it. Now, because these people have different stages in life, or they stand in different stations in their life, so therefore that requirement is something that the law needs to take into consideration. And the differential treatment then, Hart says, becomes essential. And it is something like, let's say in Article 14 of the Indian Constitution, like we have equality, but we also have Article 15 and 16, which is imbibing these understandings. And we do know that how and why these laws are important, at least the laws enacted under Article 15 and 16. But whatever, Hart goes forward here and says that since we are basing our understanding on mutual forbearance, history has always shown that even if most of the people need this mutual forbearance, there are always some people who do not need, and they do not pay heed to these kind of mutual forbearance. So either for them they are too powerful to need mutual forbearance, or their immediate requirement becomes more more important to them rather than thinking about the long-term security and other things that the society is built upon. And this is exactly the point where Hart comes up and says we need sanction. So